cover off AI in the workplace. This is a big buzzword at the moment. I'm hearing AI. I mean, we have been for the last 12 months or more, haven't we? More
Yeah.
and more and more and more AI. But does anybody really know what's going on with AI? All I'm seeing at the moment is that a lot of jobs are being lost because of processes, AI processes. So there are increased redundancies because of AI intervention on sort of more administrative roles and process-driven roles. Last week, there was a case that was published called the R against London Borough of Haringey, and that involved, well, it was more pertinent to the legal sector, where solicitors had relied on AI generated cases, which were false and hadn't ever been published. And they relied on those in arguing their cases, and it was a contempt of court hearing. They didn't get, they weren't, didn't decide that they had committed contempt of court, but they were heavily criticised for using AI tools without any human intervention in determining whether or not those cases were accurate. And quite right too. One of the early paragraphs in that judgment states, artificial intelligence is a tool that carries with it risks as well as opportunities. Its use must take place, therefore, with an appropriate degree of oversight and within a regulatory framework that ensures compliance with well-established professional and ethical standards if public confidence is to be maintained. As AI develops further and is used more and more, it's important that we try and keep up to ensure business protection and maintenance of standards. It's being talked about as affecting all areas of the employment journey. So recruitment, onboarding, during employment and termination. So just starting then with recruitment, what do we need to be aware of? Well, firstly, candidates are using AI, and you'll know this, Eloise, using AI to complete application forms and cover letters. It's been reported that 46% of UK applicants use AI to apply for jobs. AI may be used to answer questions asked of candidates during the application process, so pre-interview on application forms, or by job applicants to try and fill in gaps of their employment history using AI-generated plausible explanations. And those kind of matters are then very difficult for the employer to investigate, or the potential employer to investigate and to determine whether or not they're truthful. Yes, Eloise.
Sorry to interrupt. I was going to say, I'd also add in there, people are using AI during virtual interviews.
Yeah,
So,
we'll come on to that.
yeah. Oh,
Yeah.
sorry.
No, go ahead, because that's really interesting.
Because they can have AI up running along the same time and with their CVs, and AI will generate answers to the questions as they come in.
Oh my goodness.
If somebody's a real pro with
Yeah.
AI, most
Yeah.
people aren't.
Yeah. So, I mean, to safeguard against that, employers or potential employers of individuals are going to need to have the technology, aren't they? To ensure that they can see on screen what individuals are doing. Now, that's going to be difficult if they're using another screen. So, I mean, I think firstly, employers are going to need to reduce their reliance on pre-submitted tasks. So the old days of completing a scenario and sending it in as part of your application, I think, are long gone, because we just can't determine whether or not it's the individual or AI. So it could be that you're asking candidates now to draft tasks or conduct tasks live. Everything's live, in person, preferably. If that's not going to be possible, then yes, via virtual meeting, but conducting a live task. Clearly, if a candidate has a disability, and that might be autism with associated slow processing, they might be required unreasonable adjustments to pre-prepare. And really, it's going to be very difficult to determine whether or not in that pre-preparing and being given advance warning of questions, whether they are going to be relying on AI. And therefore, what we need to do is include honesty declarations or confirmation in our offer letters. So, for example, the affirmation or the confirmation that you confirm all information and documents you provided during the recruitment process are true, complete, and not materially misleading. If any statement is later found to be false or incomplete, the company reserves the right to withdraw this offer or terminate your employment without notice and recover any losses arising. You may already have this. And whether you want specific reference to AI because you feel it's becoming more of an issue, then that should be referred to expressly. You could include a declaration that candidates are asked to complete during the recruitment process, which requires the candidate to confirm if they have used AI during the application process, and if so, how they have used the tool. We are going to have to accept that most people are many people are going to be using AI in application. So let's ask them, how did they use it? You could use an AI detector, GPT-0, to determine what extent an AI tool is being used. And you can scan it, can't you? And it comes up with determines how much of the document that's presented to you is actually generated by AI. If you do that, you'll need to include reference to using an AI detector tool in your privacy notice that you issue to candidates, so that they know that you will be using or potentially using an AI tool. And I'll come on to what also should be included in your privacy notice as well later on. So that's the 3 and 4 there in the on the slide. What then happens if we're using AI to shortlist candidates? So this again is becoming more common, particularly with bigger employers, and has been for some time actually. So employers using AI to shortlist. So this is shortlist for interview. If employers are doing this, they will need a transparent and clear privacy notice to confirm they are using AI to shortlist candidates and potentially to detect applicants' use of AI in the application process. The privacy notice should also confirm how the individual can challenge the outcome of the shortlisting process. It should also tell the applicants their rights, including the right to request for human review if a significant decision is made using AI. And that's stipulated in the GDPR legislation. So it is made clear that if a significant decision is being made in respect of an individual using automated means like AI, then human review needs to be, there needs to be some amount of human review in respect to that process. You will also need to conduct a written impact assessment to comply with GDPR. The impact assessment shows that you have considered the risks to candidates and details how you have overcome these. And then that assessment should be stored centrally. Also, in order to ensure that you're complying with your obligations under the Equality Act, you will need to use bias testing. So the aim of the bias testing is to check that the AI tools making the decision do not impact any protected characteristic disproportionately. Bias testing is used to ensure that the AI tool you are using is not biased against one particular characteristic over another. So, for example, Amazon system, it penalised applicants some time ago now, penalised applications that included the word women's on there. And for some reason, the effect of AI system, it taught itself that male candidates were more possible. So it resulted in the women's applications being disregarded, or a higher number being disregarded. So it's important because AI tools can be wrong and they can be biased to do this bias testing. So you should do the bias testing every 6 months, depending on how often you're recruiting, and retain the scores for 3 to 6 months, which is obviously the limitation period for bringing claims. To do this, so to do the bias testing, you can anonymize a group of CVs and then obtain a selection of those with a particular characteristic. So out of those, you choose a group of all men or all women. And you then determine the success rates and compare the success rates of those with the particular protected characteristic over the others that don't have the particular protected characteristic. So, in terms of a small to medium-sized employer, this can be pretty low level. You don't have to go through every single application. It can be just a sample. And depending on the numbers involved, if you've only got, I know this is unheard of these days, but if you've only got, 20 people applying for a job, then, and you're using automated means to shortlist, you can use 5 of those to do the bias testing. But the most important factor is to keep humans in the loop. So AI should not be used in isolation when making significant decisions, and humans will need to have this input. They don't need to review every application, of course, but there need to be sufficient human involvement to review everything, and that could be done through sampling. And this involves humans reviewing a summary of the shortlisting decisions made by AI and checking for unusual patterns or particular protected characteristics being rejected. It's important to be able to show that human oversight, human review has been conducted. What about when you're onboarding? So contracts of employment. So many people, many businesses are using AI tools to draft contracts of employment. That's great as a starting point, but you do have to be very careful because, as we all know, there has to be particular provisions in a contract of employment to ensure that you're complying with UK legislation. And an AI tool might spit out something that's relevant in the US, but not in the UK. Also, there's needs to be now specific reference to AI in some of the particular clauses that you have in your contract. So, for example, that might be the IP clause and it might be the confidentiality clauses. So, what you'll be saying in respect of an IP clause is to make it clear that the ownership of any works created by an employee using AI will vest in the employer. And in respect of a confidentiality clause, you'll be saying absolutely no confidential information or personal data should be being uploaded to an AI tool. You'll need to have that privacy notice applicable for employees, contractors, and workers updated. And you'll need to include in there how employees are required to use AI in conducting their roles. Most people are going to be using AI in their roles, whether it's marketing to draft an article, whether it's legal to get an analysis of a particular piece of legislation. it's happening all the time. So it's important for employers to actually stipulate in their policies when an employee can use AI. And it's important to say when they can't use AI. It needs to be made clear that no confidential information or personal data must be inserted, pasted in, typed in to an AI tool. And the policy should also detail that any communication or work drafted using AI should be checked by the relevant personnel before it is sent out. Appropriate reference should be made to the disciplinary policy if the AI policy is breached. And this is going to become more and more important. During the employment then, the top risk for employers is employees pasting confidential information or personal data into an AI tool. People are still thinking that if they just copy and paste a question or a company stat that they want a view on into an AI tool, that it's confidential, that it will remain confidential. When in fact, what the tool is doing potentially is using that information and spitting it out to another user. So employees cannot copy and paste or type in any confidential information that has been obtained during their employment. It can be seen with the case of Samsung Electronics, who banned employees using ChatGPT after discovering staff had uploaded sensitive code to the AI platform, resulting in an accidental leak of sensitive confidential data. Although the severity of the leak was unclear, Samsung was concerned that data shared with the AI chatbots gets stored on the servers owned by the companies operating the service, like OpenAI, Microsoft, and Google, and there's no easy way to access and delete them. The company also feared that the sensitive data shared with the likes of ChatGPT could end up being served to others. And this is because by default, ChatGPT saves a user's chat history and uses the conversations to train its models, but so that the information could then be served to other users. So in order to, sorry about that, it's my dog. So in order to protect confidentiality and comply with GDPR, employers should use policies and technical controls. As we've said, the policy has to include a statement about pasting and inserting confidential information into a AI tool. And it should be stated that if you wouldn't post it on a public forum, don't post it onto AI. What are the appropriate technical controls? So they include switching off the improvement setting, which you'll find in most of these AI toolbox in the settings. So the improvement setting, so that it's not then potentially being used for and saved and reused. Also in the temporary chat, so you can actually turn on temporary chat, and that should be switched on, because otherwise it could save the chat that you are inserting. And the temporary chat is only there for a temporary period of time. Also, employees should be told to anonymize names and not use personal data, of course. So due to the mechanics of AI, employers also need to be wary of being accused of misusing other employers' information, confidential information that may be spat out to their employees when using AI, and because claims could be brought against those employers for having that confidential information. Grievances and claims then. During employment, employers should be wary that grievances could be brought by employees about decisions being made about them using AI tools. Explaining decisions based on AI may be impossible due to the algorithm, and it's going to be very difficult to explain how you've made a decision if you don't understand the algorithm, which is most likely. Proposed new law will require employers to prove that their AI tools are not discriminatory, which means that the starting point will be bias, and it will be for the employer to disprove this. So that's interesting. This new law is proposing that the onus will be on the employee to actually disprove bias. Employers will also need to be live to possible harassment using AI tools, and be live to that. And then lastly, dismissals. So just be wary if you're a big employer and using algorithms or AI to select employees for redundancy, for example, which is becoming quite common or more common in big employers when they go through large scale redundancies. They have a selection criteria, and then they score employees against that selection criteria. Because if you're using an AI tool to do that, then again, you've got to be careful that you don't breach the Equality Act, and score somebody lower related to a protected characteristic using that AI tool. So again, human involvement in those kinds of big scale, large scale redundancies is going to be really important. And that's it. So I finished the AI section. If anybody's got any questions on that, then obviously let me know. I appreciate it.